Is there any public input?
I did ask for public, didn't I? Or did I not?
No.
I did not? I'll ask for public input before I go forward again. Hearing none, we'll go to the next item of business. Commission General Regulations 378, Guide License Changes, LCB File Number R006-10. Rob.
For the record, Rob Buonamici, Chief Game Warden. LCB file number R006-10. What this regulation, the changes in this regulation address are some kind of cleanup issues we saw with the previous regulation as a result of just experience over time. And what this regulation basically does is currently the guide application period for master guides is from October 1st through December 1st. Well, that coincides with the hunting season when the guides are out there busy doing what they're supposed to be doing. It coincides with the hunting season when we're out there, supposed to be out there doing what we're supposed to be doing and investigating poachings, investigating illegal guiding, and so forth. So to make this a win-win for everybody, we get together with the Guides Association and propose changing the dates from July 1st to October 31st. Now in your packet, it shows August. So July 1st to August 31st. In your packet, it shows August 30th as the dates. That was just an oversight on our part, not realizing, you think we know that August has 31 days, just to make it easier so we can tell the guides you have till the end of August, and it just makes it cleaner. So that's the only amendment we're proposing is to what we proposed is the August 31st as opposed to August 30th. So that's one change that will be a win-win, like I said, for both the guides and us. And then to coincide with that, there's a period of time when you can take the master guide test. And currently that period of time is April through November 30th, and we're proposing changing that to January. Date was Patreon.
August 30th.
For January 1st to January 1st, August 30th.
Yeah, should that be 31?
31st?
And we'd like to make that, again, the 31st. So everywhere in this whole document where you see August 30th, we would like to make August 31st. And then the final change is in section 5, and that is with regards to the issue we just had. The department may deny an application for or revoke a suspect's guide's license for any of the following. Just some cleanup there, and in addition, on sub 3, it says a conviction of any felony. Scratch that and make it A, a felony, or B, a crime involving physical violence, theft, or fraud. And just as a note, those could be misdemeanors as well. And then just some cleanup in subsection 10 there. 2 or more convictions of any provisions of 484 A to E inclusive in chapter 488, and then failing to report to the Division of Enforcement as opposed to Bureau. So those are the proposed changes. The guides are.
Just
Yes,
mention
sir.
the insurance part.
Oh.
You didn't talk about that.
The insurance as well, that provision raises the limit from up to now to 25,000, I think. Yeah, from 5,000 to 25,000 for property damage that the guides will be required to have. As we all know, $5,000 nowadays, isn't much.
I got a question. I remember a while back, some guys were talking to me, and they said that having this short date of August 31st, they don't even have clients by that time, and closing that. And I guess some of the guys wait till they get clients, evidently. And he said they don't even know if they have clients by August 31st before they go and apply to get their license. Is that a problem?
It could potentially be, depending how they're running their business. If they're running their business based on, well, if I have clients, I'll run a business. If I don't have clients, I won't run a business, as opposed to I'm in the guide business. So, yeah, to answer your question, it could have an impact.
So why is it so important to cut it so short, not leave it a little bit longer? So if they do have a client, they can apply for a guide's license. Why? I don't see the reason why we're shutting it off on August 31st.
The reason is the hunting seasons, as we know, even start in July with antelope and so forth. But the reason is it takes time to process those applications, especially if they're a new application, to do the background and so forth. And we're just putting ourselves in kind of a lose-lose from the standpoint. You know, the guide calls, says, hey, I got a client, I want my license now, and we're going next week. Well, we don't have time to process the application. We look like we're not user-friendly. They're upset because, you know, they can't get their license just like that. This just gives us time. You know, everybody that's serious about being a guide, that's the application deadline. And, you know, it just makes it cleaner. I mean, if it were an issue where they wouldn't have a problem, you know, if it took us 30 days to do the background and all that, and they had a client and then they couldn't guide their client, if they're, you know, willing to say, refund the client's money or what have you, I mean, they can't even take money then. And that's one of the other issues, is you really can't be soliciting for clients unless you got the guide's license. So with that issue as well, I mean, they shouldn't be out there soliciting, saying, you know, I shouldn't be coming to a potential hunter and saying, hey, I'll take you hunting, you know, $2,000 for the deer hunt, and I don't have a license. And then you, the hunter, gives me the $1,000 deposit, and then finds out that Rob can't get a license because the department doesn't have time to process the background. And so they just booked with an unlicensed guide, so to speak. So there's a myriad of reasons for that date.
I know a lot of guides, even guides in Alaska, that I've talked to, they say, well, if I get some clients, I'll apply for a guide's license, but they tell you up front. That wouldn't be illegal, would it?
No, as long as they don't book
Right.
a hunt,
Right.
all that. If I come to you and say, hey, I'm thinking about getting a guide's license next year, if you're interested in booking with me after I got my license, you know, but if I'm at a sports show or something and I'm advertising as a guide, you know, come book with Rob's Guide Service, and Rob's Guide Service doesn't exist yet officially, that's problematic. Rob's gonna get a ticket.
Anybody, Commissioner McBeth?
Yeah, along the lines of that discussion, it just seems to me that we want to portray our guides industry here as being guides that are in legitimate business of guiding, and that we're not dealing with, you know, guys that are, you know, making a decision based on, I mean, you're either a guide or you're not a guide. And if you're in the guide business, then you should be licensed just like any other profession, and step up and deal with, you know, your business and what clients you get, based on the draw. And I mean, that's just part of being in business. And you either are in business or not in business. And I just think we ought to, I'm interested to hear what the Guides Association says about this regulation. I'll just qualify it. But it seems to me that, we need to have something that's firm and then have, in plenty of time for, guides to get licensed at a time when it's convenient for everybody. And you either make fish or cut bait. You're a guide or you're not a guide.
Any other, before I turn it over to the public? Thank you, Rob.
Thank you.
Let's turn it over to the public. We've got
George Corner was the first one with a card specifically stating this item. The only one that specifically stated this item.
For the record, George Corner, representing the Nevada Outfitters and Guides Association. I want to thank the Department of Wildlife. Again, we work closely with them. We work closely with them on this, and the Guides Association does support the proposed changes. One of the things that Rob didn't point out on the changes in the insurance requirements there to be consistent with what the federal land management agencies require. So now everything's consistent. In other words, you have a permit with the BLM, Forest Service, the BLM, all the requirements are the same. And then the time periods, I'll just give you an example. Every year, myself and a lot of the other guides, especially with the landowner elk tags, somebody will go out, sell landowner elk tags, find somebody that's willing to buy them, and then they'll approach me or another master guide and want us to hire them as a sub-guide so they can take those people hunting on our insurance, our license and all that. Same thing with the time periods here. People that got the money, well, you can even do it with your bid tags, governor tags and all that. Sell big money tag, you got the money. If you got the time, you can apply, get your master guide license, take those people hunting. And it goes back to what Commissioner Macbeth pointed out. We're trying to discourage that from happening. We're trying to protect our business, and this is what this goes toward. Any questions?
I've got a question. I've just heard from other guides, and I'm a little mixed up. Now, what percentage of the guides, is this just a few guides you represent, or do you have 90% of the guides and you have meetings and they all say the same? Or how many guides in your organization that feel this way the way you do?
We didn't poll them, but our members of the association that attended the meeting voted for it, and I couldn't give you a number. Department of Wildlife be able to give you up-to-date numbers on the numbers of guides that belong to the association as opposed to those that are just licensed as guides.
You don't know
We don't represent all the guides in the state.
You don't know the percentage of guides you represent?
No, I couldn't tell you that right off.
You got a number?
Couldn't even tell you that right off. I'd have to go back and do some counting.
I've heard some other guides say that this impedes them because they get clients at the last minute, like you say, and I don't know if you represent 95% of them, I'll take your word for it, but you represent 3 guides, I wouldn't take your word for it.
Well, we represent more than 3, I think, between 40 and 50
Percent?
members.
Numbers?
And if you have somebody that coming in at the last minute wanting to get licensed, they're not a guide. They should already be licensed.
Yeah, I know. Okay, any other questions? Thank you. Any other public comment on this? Tom?
I'll defer to law enforcement.
He'll be up in a minute.
Thomas Wilson, Washington County Advisory Board. We concur with the recommendations, with the exception of Section 5, subsection 3, and we had more of a question involving this, and I gave Rob a heads up that I was going to be talking about this. Section 5, subsection 3 adds that the department may deny an application or revoke or suspend a guide's license for a conviction of a felony, and what we've done, or what has been done, is added, or a crime involving physical violence, theft, or fraud. Now, theft, you take out the felonies. crimes involving theft and fraud are what we call crimes of moral turpitude, and we don't have a problem with that. But the question that we had were the non-felonious crimes of physical violence, and based on my experience, there are really only two. Domestic battery, or domestic violence, to call it whatever you will. First and second offense are misdemeanors. And what we call simple battery, that's a misdemeanor. Anything else that's more serious is going to be a felony if it's involving domestic, or if it's involving physical violence. So then the question became, okay, well, what's the connection between denying a guide's license or revoking a guide's license and a conviction for simple battery? And it's been my experience as a prosecutor, when I was a prosecutor, that we had so many cases pled down to simple battery, it was insane. And it's misdemeanor. From a defense attorney's point of view, if you've got a relatively serious case and the defendant actually might have a cognizable legal defense, self-defense, defense of others, whatever the case happened to be, and the district attorney came to you and offered, well, why don't you plead it to a simple battery and we'll all go home, most defense attorneys jump on that because they'd rather not roll the dice on a more serious crime that's going to involve a potential felony conviction. We'll plead the client to a misdemeanor simple battery, pay a fine, and go away. So we were a little confused as to the connection between potentially a simple battery and revocation of a guide's license. And understand also that in the realm of criminal law, when you're talking about battery, that's a general intent crime. It is not a specific intent crime. So I don't have to intend to hit somebody in order to be convicted of a battery. All I have to do is intend to act, and the act results in somebody being touched, and that's all it needs. So it's very easy to get from a prosecutorial point of view, it's very easy to get a conviction for battery. But the question becomes, we've got 19 on this bill, or this amendment, 19 reasons to revoke a guide's license, and I'm in agreement with all of them, but is there a nexus between a simple battery and revoking a guide's license? And we're not talking about a felony conviction, and that was the concern that we had. If there is a connection, we might be in favor of it, but we couldn't find one.
Commissioner McGrath?
Yeah, Chairman, I have a question. Since you have been a prosecutor on a domestic battery, I mean, isn't it the rule that if there is a battery by even one spouse, then both of them go, right? Is the charge a battery as against both?
Yes. Well, it depends on the circumstances. The real problem, and I got to be careful because you got to be PC when you talk about domestic violence. But the issue with domestic violence and consequential circumstances, such as a denial of a license or revocation of the Second Amendment, things like that, is on an allegation of domestic violence, it's an automatic arrest. The police do not have the authority to cite and release. They've got to take them out, and they've got to take them to jail. The second part is, from the district attorney's point of view, we've got a state law, just like we do on DUIs, that the DA must prosecute. Cannot plea bargain a domestic violence case, even if those circumstances might warrant, well, the guy really didn't intend it, or this really was mutual combat, or there are some other mitigating circumstances. If the DA believes, hey, it's here beyond a reasonable doubt, the DA must prosecute, even though the crime may not have warranted all the ramifications that go with a domestic violence conviction. I know there are a lot of lawyers that are waiting for the day of the legislature to take that up, and I'm not sure they're really willing to open that Pandora's box, because there's a lot of, obviously, politics involved in it. But it's an automatic arrest, mandatory for the police, and it's an automatic prosecution from the district attorney's office.
Commissioner Quirrell?
Thank you, Chairman. We just upheld the revocation of a guide license based upon a misdemeanor citation. You're saying that we should...
No. And I sat through the hearing, and you upheld the revocation of a guide's license based on a misdemeanor citation that directly related to his actions as a guide, his actions in the field. He had two clients at the same time, and you can't service them both. That's directly relating to his ability to be a guide. If a guide is off duty, he's in a bar, and he walks up to his friend. Well, he doesn't do that, but a little harder. That's a battery. What I just did was a battery. It wasn't intended to be a battery, but that was a battery. Please don't press charges.
Suing a guy.
Good luck.
So
He knows a good attorney you could have.
We got a lot of witnesses.
So I think the concern was, here's an act that has absolutely nothing to do with the guide's ability to perform his actions and do his job. It was completely unrelated, and whether or not that should serve as a reason to revoke his state license. You know, I'm a lawyer. Did what I just do, was that grounds to get my ticket pulled, or if I was a plumber or something like that, you know, we yank licenses for things like this. And that was the concern that we had as an advisor.
Geez, I'd help John maybe on that.
Chairman. Chairman.
Commissioner McBeth?
Tom, just to follow through then, given that the hearing that we just had, and given the statute that deals with revocation of a license, and it is cast in terms of May, so if a battery like that comes before this commission, and we do have a certain amount of discretion, can we take into account the nature of the battery in determining whether to revoke the license based on the way you understand the way the statute is read?
You certainly could. And if this were to be implemented as written, it would certainly be at the discretion of the commission. Well, this was a push in a bar, and that doesn't amount to much. And this was really hey, you really beat the guy, and we're going to yank your license. You certainly could do that if it's implemented as written. The downside to it is, we just saw how difficult that was, the proceeding sitting as an administrative court. You might have a lot of those. And
Yeah.
I mean, how much work do you want to do as an
And I guess
administrative
just to
court?
follow in response to that is that I would assume that the department has the discretion to know when to bring those kind of cases and when not to. And I think that, every time we start discussing these with Chief Buonamici, he emphasizes how much discretion the department has in the field, as well as, ultimately making a decision to bring a case.
Right.
And I can see where there are going to be factual situations where, maybe the battery is bad enough that, we really don't want that kind of a person being a guide. But at the same time, if it's really just one of these kinds that are, don't really weigh in on that, or there's, mitigating circumstances or something like that, and so do we leave it the way it is and let the department first bite at the discretion, and then if the department decides that they want to bring it, to go forward with it and then bring it to the commission, we'll have the discretion again, to make that decision.
You certainly do, but I caution you to seek advice of counsel, because we're talking about the revocation of a state-issued license. And if you start treating people differently for the same crime, you might get yourself into a situation that you don't want to be in. I know there is some discretion, but there's also, these are the things that, red flags go up in lawyers' heads all the time. You want to be real careful about, well, this part yes, this part no. But if you start treating people differently for the same offense, there's a potential there that you could get yourself into trouble, and I'll leave you to talk to the lawyers about that. I can see him shaking his head going, yeah.
And I don't think this changes the current procedure where the department makes the initial decision and the commission sits as a reviewing administrative court for that.
Any other comments? Thank you, Tom.
Thank you.
Any other public comment on this before I? Huh? Okay, let's bring it back to the, what? Rob?
If I could, Mr. Chairman, for the record, Rob Buonamici, Chief Game Warden, just to address your concern about who was notified of this and so forth. On October 1st, 2009, we sent out a survey to all the guides in the state. So they're all aware of the regulation, all aware of the change. So we based our regulation on the results of the survey.
So these are results.
And then we had subsequent.
Majority of the guides wanted it, and is that what you're saying?
Yeah, and this, we had further discussion with solely the members of the Guides Association at their meetings. We did not have discussion with all the other guides that had opportunity to weigh in on it.
So you've got the majority of the guides there?
Yeah, we sent the survey to all the guides. I can't off the top of my head tell you how many guides responded, but they all received and had opportunity for input.
Commissioner Ray?
I'm thinking, it's basically the question for Mr. Buonamici is, currently, from what I've heard and seen here on this, I'm in favor of this regulation with the exception of the physical violence portion, crime involving that, and why would I leave physical violence in there? I mean, clearly felony is already taken care of. Theft or fraud, I'm clear on that.
The reason we feel the physical violence is appropriate there is when we license somebody, permit them as a guide, a license agent, what have you, they represent Nevada Department of Wildlife. They've got our stamp of approval. And if we have somebody that has an assault or what have you on the record, we're going to look at it on a case-by-case basis. You know, was it just touching their buddy, you know, at the bar, or was it a bar brawl type deal? So we're going to look at that. And yeah, for the hunters themselves, should we be overly concerned? Maybe not. You know, they're big boys, girls, gals, all that. But by the same token, many times they'll bring family members on the guided trip with them, whether they be kids or what have you. And do we want somebody that has displayed a propensity to violence for them to be entrusted with those folks and our stamp of approval saying, hey, we did a background, they're good to go. Your family will be safe with them. I mean, what's our civil liability in that instance?
Commissioner Capra?
Thank you, Mr. Chairman. My concern is that Mr. Wilson, in his testimony, indicated that many of these more, maybe even felonious type activities in that are plea bargained down to a misdemeanor. So there is differences between them. If you have, I don't know whether you mentioned the term 90%, but I thought I heard it in there someplace of those, that you may actually have had an egregious crime for which he only signed off on a misdemeanor. So I think they have to have some, area in which they can look at that before they agree to licenses. Because I agree with Mr. Buonamici. We're putting not just his stamp of approval, but the commission's stamp of approval on these people that are licensed.
Mr. Chairman?
Commissioner Howell?
Rob, you sent that survey out to all the licensed guides in the state, right?
Correct.
How many was that?
We've got a little over, I think like 102, 104 licensed master guides.
So the previous gentleman had about 50% then of the total.
Commissioner McGinn?
Chairman Lynn, Rob, does a master guide have to be a resident of Nevada? I mean, did you send it out to all master guides, whether they were residents of Nevada or not?
Yes, it went to all the master
Because it's
guides.
my understanding that guides can now, from other states, can be licensed by the state of Nevada, right?
Correct.
Okay, so
it's
all
always been
guides
that way.
got, all
Correct.
guides got, okay.
Okay. Thank you, Rob.
Okay.
This was an information item. Let's go to the next item on the agenda, the order